As the Delhi riots are concerned, the Supreme Court has rejected Delhi Police's plea. The Delhi Police challenges bail to the three accused. The Supreme Court says that the High Court's UAPA remarks must not be used as a precedent. The High Court had termed the invocation of a UAPA as frivolous. Well, that is the big breaking news that we are getting you at this point in time, which comes in from the Supreme Court as far as the Delhi riots case is concerned. The Supreme Court has rejected the Delhi Police's plea. The Delhi Police challenged the bail given to three accused. The Supreme Court says that the High Court's UAPA remarks must not be used as a precedent. High Court termed the invocation of UAPA as frivolous. And to get us more details, I'm joined by my colleague Harish. Well, Harish, kindly break it down for us as far as the statements and the observations made by the High Court and the Supreme Court, where the Supreme Court now says that the High Court's UAPA remarks must not be used as a precedent.
Yes, there are two aspects to it. Number one, Supreme Court has dismissed the appeal filed by Delhi Police challenging the Delhi High Court order which had granted bail to Asif Iqbal, Tanha, Devangana Kalita and Natasha Narwal in the Delhi riots case. They were booked under UAPA, and one of the key reasons why the bench dismissed the petition was that Solicitor General Tushar Mehta, who was to appear for Delhi government, could not make himself available last several times, and today when the matter was taken up and the matter had been adjourned repeatedly. At the same time, Supreme Court also made it clear that High Court's remark on UAPA should not be used as a precedent by any accused and as a precedent. And it should note that Delhi Police had also sought expunction of these remarks. Remember, while granting bail to the three accused, High Court had slammed the misuse and frivolous invocation of UAPA, noting that it seems that in the anxiety to suppress dissent in the mind of the state, in line between the constitutionally guaranteed right to protest and terrorist activity seem to be getting somewhat blurred. If this mindset gains traction, it would be a sad day for democracy. So, in fact, Supreme Court said that such interpretation of a statute cannot be made during a bail hearing, and therefore these remarks made against the constitutionality of UAPA cannot be used as a precedent by any other accused in any other case. So these are two aspects. Number one, Delhi Police plea has been dismissed. Number two, Supreme Court very categorically said that all remarks made by the High Court against the UAPA cannot be used as a precedent by any other accused in UAPA cases. Back to you.
Well, thank you, Harish, for putting things into perspective for us, where the Delhi Police says a bail plea to the three accused now stands dismissed by the Supreme Court. And the Supreme Court also says that the High Court's UAPA remarks should not be used as a precedent in other cases.